Hello and welcome back to Coin Lady channel. How long will Ripple's believers keep their faith after the SEC launched an assault on it? By mid-2023, how much will XRP cost? In response to a filing back and forth between Ripple and the US Securities and Exchange Commission, we will address one of Ripple's key arguments against charges that it sold unregistered securities in connection with XRP. Ripple plans to oppose the SEC's move for summary judgment in its favor by arguing that the SEC violated its fair notice rights. As an affirmative defense under US law, Ripple maintains that it did not get reasonable notice that the selling of XRP would be prohibited. However, according to recent judicial judgments on the matter in SEC versus Commonwealth Equity Serves LLC determined earlier this month, Ripple may not be able to invoke the reasonable notice defense. A fair notice argument using the same facts as Ripple's was likewise dismissed by the court. The court's attention has been drawn in that regard by the SEC. In particular, it ruled that the defendant lacked standing to raise the fair notice defense because the SEC charges were predicated on a decision from the 1960s. This would be the case even if the defendant were correct that the SEC had been aware of the damaging behavior for over 20 years. This remained true. A lack of previous enforcement of a regulation is, therefore, not an excuse for its infringement at the present time. The SEC argued that the court should reach the same conclusion since both arguments are based on a Supreme Court precedent from the 1970s known as the Howey test, which determines whether an offering constitutes an investment contract and is therefore a securities offering. In a swift response, they explained that the Commonwealth case didn't apply since the defendants there hadn't provided any evidence from the time period in question to back up their claim that market participants lacked fair notice. In contrast to its own case, Ripple argues that there is substantial evidence suggesting that the sale of XRP was not viewed as a security offering by the general public. The defense also argued that, since the court had previously sided with the defendants on the issue of fair notice in Uptime, the case upon which Commonwealth is based, it should do so again. Ripple's response stands out, even though it is unclear whether or not XRP was launched via an ICO, because Upton held that the defendants in that case could rely on a fair notice defense, but a US federal court has already ruled that opinion does not apply in Howey securities cases. The conclusion that Albury was not given fair notice is not dependent on this point. And like Lawbry, Ripple maintains that it did not attempt to launch through Sue's eye. Even while the current court is not required to follow these examples, no one can doubt their persuasive power. Someone who does not meet the Howey standard is not likely to be saved by the fair notice argument. The judgment date in the Ripple v. SEC lawsuit has been delayed for 2 years and 120 days. Despite widespread belief among lawyers that a verdict is imminent, no one knows when it will be released. Judge Annalisa Torres is under extreme pressure as a result of this action, which has strained relations between the SEC and the Commodity Futures Trading Commission, handcuffed it to Congress, and disrupted the cryptocurrency industry. Johnny Deaton, an attorney for the XRP community, claims that the SEC versus Ripple case is the most significant no-fraud enforcement action taken by the SEC since 1946. He added that Judge Torres is taking her time and thoroughly considering every statement because of the importance of the case. Judge Torres should know she's dealing with a conservative court if the verdict goes against Ripple. A judgment is expected to be handed down by the end of April, according to the directions of Judge Torres, and if it goes in Ripple's favor, she will have to defend it before everyone. After 52 days, Judge Torres has finally issued his ruling on the Doorbit petitions, and XRP community member Ashley prospers. Judge Torres has been under a lot of criticism because of the significance of the rippling viz. SEC court case for international business and finance. The verdict is expected soon, but nobody knows when it will be announced. The stakes in the litigation between Ripple and the SEC are far higher than they were before. The crypto community is holding its collective breath as Ripple and the SEC battle it out in court over allegations that the blockchain firm issued and traded XRP as unregistered securities. The SEC has claimed that the leading blockchain company violated regulations by selling XRP. And it wants the court to rule in its favor with a summary judgment. Yesterday, Gary Gensler, chair of the Securities and Exchange Commission, spoke before the House Financial Services Committee. The SEC was peppered with important issues, the most vital of which was whether or not he views XRP as a security. Warren Davidson of California asked the SEC chairman a pivotal question about whether or not XRP is a security. When asked to respond categorically, the SEC chairman declined. Instead, the SEC chairman has stated that the issue of whether or not XRP is a security is now being litigated. When questioned whether or not Ethereum ETH is a security, Gensler again declined to answer, citing the fact that the chairman of the SEC has said XRP is a security and we are currently involved in litigation over this issue. Last year, Gensler surprised the cryptocurrency community by saying that he believes only Bitcoin is beyond the authority of the SEC. Due to his strict approach to enforcement in the financial markets, especially the Bitcoin industry, many people believe that Gensler was unfit to lead the agency. It's worth noting that Representative Warren Davidson, RO, shared these sentiments and introduced legislation to remove Chancellor and restructure the SEC chairman Gensler. According to Davidson's representative, the SEC has to be reorganized because of the agency's history of failing to safeguard investors and using its authority inappropriately. After describing some of Gensler's faults and abuses in office, Davidson introduced legislation to remove him as SEC chairman. I've proposed a bill that would replace the SEC chairman with an executive director who would report directly to the board and have full authority over the agency. In the matter of Ripple versus the SEC, Judge Annalisa Torres has not yet delivered a judgment. As a result of Congress shedding attention on gender insults, ineptitude, and misconduct, it's possible that Ripple will profit from laws meant to remove kinder. Judge Torres will feel forced to decide in favor of Ripple. Please leave your thoughts in the section below. If you like this video, give it a thumbs up on YouTube so you don't miss any important future updates. To receive quick updates anytime a new video is posted on Coin Lady channel, please remember to hit the subscribe and notify buttons. You may see our other XRP history videos. In the meantime, you may catch us in the video below. See you in the next video. Bye.